Today we'll talk about conciliation as one of the settlement machinery. Conciliation is a voluntary process in which a professional facilitator assists employers and employee to resolve dispute when their own unassisted efforts have not succeeded. And now this process can be described as facilitated search for agreement between the disputing parties. Now what we find that like mediation, although it seems that it is similar, but there are certain differences as well. Now if you look at the Halesbury laws of England defines conciliation as the process of persuading the parties to reach an agreement. Right? Now in this particular process, it can comprehensively be defined as a non-adjudicatory and non-adversarial mechanism involving a settlement procedure wherein an impartial third party, known as conciliator, enables and steers the disputing party to arrive at satisfactory and acceptable settlement between the parties. Conciliation, as we all know, is a voluntary process, and the conciliator as such has no authority to impose on the parties a solution to the dispute. Like any other alternate dispute resolution process, the sanctity of conciliation is a mutual determination of parties to amicably resolve their disputes through an ADR. Right? Now, here, parties are encouraged to visualize options which provide solutions to the problem that has arisen. Now, the conciliation process commences when the disputing parties agree to conciliate and a neutral conciliator is appointed. Now, here comes a point of difference. Mediator is not appointed, conciliator is appointed. The party initiating conciliation sends a written invitation to the conciliator, to the other party, briefly identifying the subject matter of the dispute. And conciliation begins when the other party accepts in writing the invitation to conciliate. Thus, conciliation agreement should be an ad hoc agreement entered by the parties after dispute has actually arisen and not before. Even if the parties incorporate conciliation clause in their agreement, still conciliation would commence only if other party accept the invitation. Right? So, unlike the case of arbitration agreement that is there in the Arbitration and Conciliation Act of 1996, it is envisaged that any agreement of conciliation of future disputes will be taken up by the conciliation. It only provides for an agreement to refer the dispute to conciliation after the dispute have arisen. In conciliation proceeding, ordinarily there is one conciliator, unless the party agrees for more than one conciliator. So there can be one conciliator or more than one conciliator who would be there. In conciliation proceedings with one conciliator, the parties may agree on the name of the sole conciliator. And in conciliation proceedings, the two conciliators, each party may appoint one conciliator each. Now the parties may also request any institution or a person to recommend suitable names of conciliator. Sometimes we also hear of the conciliation board that is there to look into the matter of conciliation. The conciliation, as we all know, is mentioned in the ID Act of 1947. The conciliator may request each of the parties to submit a brief written statement describing the general nature of the dispute. At any stage of the conciliation proceedings, the conciliator may request a party to submit to him his additional information as he deems appropriate, and the conciliator is supposed to assist the parties in an independent and impartial manner. They explain the pros and cons. They explain them the total details that is there. Basically, the conciliator will bring the two parties to the discussion table, and the process of conciliation inter alia involves creating a constructive bonding between the parties to a dispute to steer them towards a resolution, because it is believed that once you get into on the talking table, more than 50% of the problem is resolved and the things can be solved. The conciliator may conduct conciliation proceedings in such a manner as he considers appropriate, taking into account the circumstances of the case. And the conciliator is not bound by the Code of Civil Procedures of 1908 or the Indian Evidence Act of 1972 that is applicable only to the court of law, which is fully judicial process. But here it is a quasi-judicial process. He is not be guided by the principles of objectivity, fairness. He is to be guided by the principles of objectivity, fairness, and justice, giving due consideration to rights and obligations of the parties. That is important as far as the conciliation is concerned. The conciliator may invite the parties to meet him or may communicate with them orally or in writing. He may meet or communicate with the parties together or with each other separately. The conciliator may hold several joint or private meetings with the parties before arriving at the final thing. The role of conciliator is to assist the parties to arrive at an amicable settlement. That is the important part of this particular settlement process. But settlement, as we said, is a voluntary thing, so it is not binding. But if it is under seal and filed in the court of law, then it becomes binding on the parties. Otherwise, it remains a voluntary thing. So these were the two voluntary processes that we talk about. Now we have got the second kind of procedure known as arbitration. Now arbitration is of two types. One is known as voluntary arbitration and the other one is known as compulsory arbitration. So let us look at the voluntary arbitration first. See, voluntary arbitration refers to the mode of settling labor management disputes by which the parties select a competent, trained, impartial person who shall decide on the merits of the case and whose decision is final, executory, and binding. Now, Section 10A of the Industrial Disputes Act of 1947 makes provisions for voluntary reference of dispute to arbitrator. Now, Section 8 of the ID Act and amendment thereafter, the Miscellaneous Provisions Act of 1956, and it was enacted with the object of enabling employees to voluntarily refer their dispute to arbitration themselves and by written agreement and for the enforcement of agreement between them reached otherwise in the course of conciliation proceedings. Now, see, arbitrator is appointed by the government. So that is the basic difference. Under this method, it is for the disputant to decide whether they should opt for arbitrator or they should not opt for arbitrator. That is neither the law nor the government compels them to have recourse to arbitration. That is there, voluntary arbitration. But law can dictate and prescribe the time limit within which the parties should choose arbitration for the resolution of their dispute. Thus, for example, under the Act, once the appropriate government decides to refer the industrial dispute to adjudication authority, the party's right to opt for voluntary arbitration ceases or vanquishes. The second thing is within the arbitration is called compulsory arbitration. If the parties to a dispute agree that dispute is to be referred to arbitration, they can make a written agreement for it. The parties need to enter into an arbitration agreement in prescribed form, that is name of the arbitrator to whom the matter will be referred to. In order to make reference of dispute to the arbitrator, it is necessary that dispute in question to be an industrial one, not otherwise, and the reference would cease to be competent if it is not industrial dispute. In case where the dispute is referred to an arbitrator under section 10A, it cannot be further referred to tribunal or to any court or to adjudication. Now, section 11 of ID Act states that arbitrator can proceed with the arbitration process with his or her own procedures as he or may think fit, provided that such procedure is not against the principles of natural justice. The industrial disputes referred to an arbitrator can be investigated and adjudicated as per the arbitration agreement. That is there. The arbitration referred to under section 10 shall not be affected by any of the provisions of the Arbitration Act of 1940. What we find that this arbitrator is always appointed by the appropriate government that is there, and the compulsory arbitration dispute has to be referred to the arbitrator because it is a compulsory arbitration procedure. Now, according to section 18 of the Industrial Disputes Act of 1947, the arbitration award becomes binding once it is enforceable on those parties who refer the dispute to arbitrator. Now, it is found that it follows the quasi-judicial process, that is submission of the dispute would be there. Now, evidence counter, evidence can be provided. There will be, both parties can be summoned by the arbitrator to explain their side. They can even bring in witnesses if required, and those witnesses will be examined and re-examined, by the other parties. And then the final award is given by the arbitrator. Now here we said arbitration award is a kind of judgment that is being passed by the arbitrator, and therefore it is binding on the parties under compulsory arbitration, that is there. Now, an arbitrator, who can be an arbitrator? An arbitrator can be a judge of a district court who has spent a minimum period of 5 years as judge, or he can be a judge of a high court spending 2 years of time in a high court. Whereas in case of conciliator or in case of a voluntary arbitrator, they can be an impartial third party who is well versed with the nitty-gritty of industrial relations procedure. Whereas compulsory arbitration, the arbitrator has to be from the court of law and appointed by the appropriate government for the procedure. The procedure, the rules also say that arbitration agreement can be referred to the adjudication process under section 266 of the ID Act of 1947. Now, the last procedure is called adjudication. Adjudication, we all know, is three-tier machinery that is there, that it comprises of labor court, industrial tribunal, and national tribunal. This is also called the ultimate remedy that is available to the disputed for the settlement of an industrial dispute, and its reference to adjudication by labor court or tribunal when conciliation machinery fails to bring about a settlement, and then it is referred to adjudication. Now, adjudication consists of settling dispute through intervention by a third party. Mind it, it is intervention by the third party that is necessary to be called an adjudication. And that third party is appointed by the government. That is, adjudicator has to be appointed by the government. The law provides the adjudication to be conducted by the labor court, industrial tribunal, and national tribunal. The dispute can be referred to adjudication if not the employer and if both the employer and the recognized union agree to do so, right? A dispute can also be referred to adjudication by the government if there is no consent of the parties, in which case it is called compulsory adjudication. As mentioned above, the dispute can be referred to three types of tribunals depending on the nature of dispute that is provided in Schedule 1, 2, or it is of national importance. Now, the procedures, powers, and provisions regarding commencement of award and period of operation of award of these three bodies are similar. The first two bodies can be set up either by a state or central government, but the national tribunal has to be set up by the national government only and not by the state government or the governments of union territory. A labor court consists of one person only, who is normally a sitting or an ex-judge of a high court. It may be constituted by the appropriate government, the central state or a state government or government of union territory, for adjudication of dispute, which is mentioned in the second schedule of the ID Act of 1947, right? Now, the issues that is there in the second schedule that is there is the propriety or legality of an order passed by an employer under the Standing Orders Act. Now, you may ask me here as to what is the Standing Orders Act. Basically, Standing Orders Act was passed in 1946, which is known as Industrial Employment Standing Orders Act. Now, before the passing of this act, the terms and conditions of employment was governed by individual contracts, but the Act of 1946 made it standardized. There has to be uniform terms and conditions that has to be prepared by the organizations, and that should be notified in advance. And that terms and condition will be applicable to all employees. It will not be governed by individual contracts, because in the individual contracts, for the same level of employment, for the same position, there can be differential terms of contract, depending on the bargaining power of the parties. So standing orders made it standard. The application and interpretation of standing orders, if it is in dispute, then it will be referred to labor court. If discharge or dismissal of workmen and grant of relief is involved, then it will be referred to labor court. If there is a withdrawal of customary concessions or privilege that was given to the employee earlier and it is being withdrawn now, that employee may become aggrieved. Now, illegality or otherwise of any strike or lockout is there, if the employer says it is illegal, whereas the worker says it is legal in terms of strikes, or if the employee says the lockout is illegal, whereas the employee says it is legal, that will be referred to labor court. All matters not specified in the third schedule of Industrial Dispute Act 1947, it deals with the adjudication of industry, will be dealt with by the industrial tribunal. So any matter that is not specified or the third schedule of the ID Act will be referred to industrial tribunal. It will not be referred to the labor court, which is there. So these are the items that is mentioned. Now, it follows labor court, as we know, follows the quasi-judicial process. The disputes are dealt with in the same manner as the proceedings of the court. Only thing is that it is not following the procedures of the court, and therefore it is known as the quasi-judicial process and known as adjudication, because it is not the court of law where you have got to pay for it. The industrial tribunal is the second tier machinery out of the three. Like labor court, and industrial dispute tribunal is also a one-man body. The matters which falls within the jurisdiction of industrial tribunals are as mentioned in the second schedule or the third schedule of the Act. So any matter that remains unresolved at the labor court or matters which are listed in the third schedule is basically the jurisdiction of industrial tribunal. The industrial tribunals have wider jurisdiction than the labor courts. Moreover, an industrial tribunal, in addition to the presiding officer, can have two assessors if that is required. So that is the kind of thing that we have, that an assessor can be appointed by the appropriate government that is empowered to assist the arbitrator, sorry, adjudicator, as far as the tribunal is concerned. Now the matters that is listed in the third schedule is, we said, all matters that remains unresolved at the labor court will be referred to industrial tribunal. And any matter which is mostly financial in nature, called wages, including the period and mode of payment, if that is in dispute, it will be referred to the industrial tribunal. Industrial tribunal, as we said, wage, including period and mode of payment. The Payment of Wages Act prescribed that all wages should have to be paid in checks. It was not should be paid in cash, not in kind. So the provision that you can be paid grains instead was done away with the act. Later on, the amendment in the Payment of Wages Act was that no cash payment will be made to the workers. All payments has to be made through checks to the banks of the individual bank accounts of the individual. The further amendment came up in the Payment of Wages Act, that it can, under exceptional circumstances, it will be paid by checks, but otherwise it will be directly debited into the accounts of the individuals where salary account exists, and the number has been provided by the employee to the employer. Now what we find that further change has occurred after the 7th Pay Commission, and during the last year the Ministry of Finance further amended it, and they said that all payments will be directly debited by the employer, for which authority has to be obtained from the Reserve Bank of India. And now all payments are directly from Reserve Bank of India, and not by any individual that is there. We also find that once we say wages, the amount of wage that is there, if it is less what has been previously been agreed to in writing, if employer is paying less, that will also form part of the dispute. If working hour is a dispute or rest intervals are at dispute, so working hour, as we know, as per the Factories Act of 1948, an adult employee is supposed to work to a maximum of 9 hours with a rest interval, minimum rest interval of half an hour that is there. But customarily, the rest interval is of 1 hour duration, and no employee will be asked to work for more than 5 hours in continuation. Maximum time is 5 hours, after which a rest interval has to be given. So if any dispute is there on this, then it is to be referred to the industrial tribunal. Now, if leave with wages and holiday is involved, leave with wages are that we have the earned leave is there, and we have got leaves which are paid leaves, the number of leaves which are being decided in advance, that is known to the employee. If that comes under dispute, then, or any other holiday is there and you are asked to work, then that is a dispute, and that can be referred to industrial tribunal. Similarly, the issue of bonus, which is a non-issue after the passing of the Bonus Act, which prescribed that 8.33% of bonus has to be paid in public sector, but for private sector it is not, and therefore what we find that the bonus remains the issue in private sector. Profit sharing, which if it was done, is one of the issues. Provident fund, we all know that 10% of your basic has to go to the provident fund as a contribution if it is under EPF, whereas under CPF, under EPF, under CPF, the contribution has to be made both by the individual and by the employer as well as by the government, and that is there. But that is only for any other employee, or if the case of gratuity is also under dispute, then it will be decided by the industrial tribunal. Shift working otherwise not agreed to will be referred to, because standing orders prescribes as to how shift working will act. Similarly, the Factories Act of 1948 also prescribes cannot be any overlapping of shifts, and there has to be a difference of minimum 24 hours between the two shifts if there is shift change is there. Therefore, if that is a matter of dispute, then it will be referred to industrial tribunal. If the rules of discipline is also in question, then that will be referred to dispute, industrial tribunal. If rationalization of work is involved, that will be referred to the tribunal. Retrenchment of employee, if that has occurred, that will be referred to industrial tribunal. And any other matter that may be prescribed by the appropriate government for adjudication by the industrial tribunal will be taken up by the industrial tribunals. The final body, the ultimate body that is available is called National Tribunal. Now, as we said in the beginning, that labor court and industrial tribunal can be appointed by the appropriate government, that is both by the central as well as by the state governments. Whereas National Tribunal, and that was one person, headed by one person, although in a tribunal we said assessors can be appointed, but National Tribunal can only be appointed by the central government, not by the state government. The central government may constitute a national tribunal for adjudication of disputes as mentioned in the 2nd and 3rd schedule of the Act, or any other matter not mentioned therein provided in its opinion the industrial tribunal involves questions of national importance only. Uh, the industrial dispute is of such a nature that undertaking established in more than one state is likely to be affected by such disputes. So if more than one state is involved, obviously it is the central government which will have to take it up, and therefore it is referred to national tribunal. It is also said that all those disputes which are concerning the grave economic crisis in the country, if that is the situation and a dispute has occurred, that will be referred to national tribunal. If there is a case of economic emergency, as we said, if there is a case of external aggression on the country, external attack, and the dispute has occurred in the industry, that will be referred to national tribunal. And if there is a national emergency, then like the emergency of 1975, then it will be referred to the national tribunal. The central government may appoint two assessors to assist the national tribunal, and the award of the tribunal is to be submitted to the central government, which has the power to modify or reject it if it considers it necessary for the public interest. And it should be noted that every award of a labor court, industrial tribunal, or a national tribunal must be published by the appropriate government within 30 days of such awards received, and that is in the official gazette. And unless declared otherwise by the appropriate government, every award shall come into force on the expiry of that 30 days from the date of publication, and shall remain in operation for a period of 1 year thereafter, which is there. So what we find that this particular machinery called settlement machinery, as we said, comprises of mainly we have the conciliation, arbitration of 2 types, and adjudication of 3 types. And mediation was also the initial process that is involved. So basically what happens that these bodies are being provided so that industrial peace could be brought on to the industry, because productivity is an important issue that is involved as far as these disputes are concerned, and therefore following it is necessary by the parties, be that the employer or the employee. Now what we find that it is not something to be bypassed. As the voluntary process, we said that we have got the grievance procedure which is there. Now the grievance procedure is basically a procedure which is completely voluntary in nature, and therefore although established in every organization, but that is sometimes only used to get the reference of that dispute to arbitration, because without passing the voluntary procedure, you cannot refer the dispute to arbitration procedure, or for that matter, for any kind of adjudication procedure that is there. And therefore, what we find that the ultimate remedy available in the organizations are compulsory arbitration, the adjudication, 3-tier machinery of adjudication, labor court, industrial tribunal, and national tribunal that is there, and that takes care of the industrial dispute that arises, and the voluntary as well as preventive as well as the settlement machinery which is there. Because what we find that mere presence of the machinery basically brings down the percentage of dispute, because they know that if there is anything going out of the hand, that will be referred to arbitration or adjudication procedure which is there, and thus we find that there is always some amount of peace between the employer and employee, the gulf that is there between employer and employee is reduced by the mere presence of these machineries that is provided in the ID Act of 1947, right? If you have any question, please feel free to ask me before I move on. Hello?
Sir, there was this slide in conciliation where you mentioned about the Arbitration and Conciliation Act of 1996. So can you please show that once again?
Yeah, I'll have to go. Sure, I'll do that. See, we talked about the Civil Procedure of 1908 and Indian Evidence Act of 1947, from which it is exempted, right? And we also talked about the acts. Where did we talk about the act? Where was it?
So yes, sir, this slide.
Okay.
Yes, sir. Oh, so just
The Conciliation Act of 1996 we talked about, right? Part
so,
3 of the arbitration.
so can you yes, sir, can you please elaborate it once again?
See, we are saying that unlike the case of arbitration agreement that is given in the Part 3 of the Arbitration and Conciliation Act of 1996, this act envisages that any agreement for conciliation of future dispute will be done by the arbitration. All right. Now, what happens that we said conciliation procedure is voluntary in nature, right? And the conciliation, cannot be referred compulsorily to the court of law, whereas arbitration, as we said, under Section 226 of the ID Act of 1947, can be referred to labor court or industrial tribunal or national tribunal, depending on the nature of the case, right? So what is happening here, that if we talk about conciliation, it is the government who appoints the conciliator, right? The government appoints the board of conciliation, and but the dispute that is to be referred to conciliation will be on the choice of the parties, whereas the choice is not there in the compulsory arbitration. Now, if an arbitrator has been appointed on a case, then it becomes binding on the parties to, get into the procedure that is there. But in conciliation, there is nothing like a compulsory kind of a thing if it is voluntary in nature. But if it has been, the parties approach the government and they appoint a conciliator or a board of conciliation, then it becomes binding, otherwise it is not, right? But procedure is that compulsory arbitration is binding. In conciliation, judgment is not given. In arbitration, judgment is given. That is being specified in the Act of 1996, right?
Okay, sir. Thank you so much.
Any other person has got any question, queries? Okay. Just a minute, please. Just
So
one
I
minute.
want to ask something. Actually, there was a network issue, so I was not able to ask. So, you told in tribunal, if a person is working on a holiday, that it is against that. But if a person is getting compensation regarding working on the holiday, will it be still against the law?
No, see, the thing is that the organizations cannot force them to work on a holiday, right? They cannot force them to work on a holiday. But that holiday, what is the nature of holiday? Because holidays are of different types. There are gazetted holidays and there are restricted holidays and there are national holidays, right?
Yes, sir.
Now, what happens that on a national holiday, all organizations are involved in that. If it is a gazetted holiday, that is also compulsory on the organizations to follow it. But if it is a restricted holiday, then organizations can ask the employee to work, and it will be considered as overtime. You cannot say that you will have to work on a holiday if the employee wants to avail that holiday, if it is a gazetted holiday, or if you are not given alternate free day in lieu of that restricted holiday which is given, right? So what is happening, that restricted holiday is to be declared as to which day you want that restricted holiday to be followed, or when you want to compensate that employee. But for the gazetted holiday or for the national holiday, the employee does not have any right. Now, in the restricted holiday, there has to be an agreement. You cannot do it on your own. And if there is a dispute with this effect, then it will be referred to matter will be referred to the tribunal, which is there. Okay. Any other question?
Sure, sir.
No.
So if it is like if a person is not getting compensation, then it will be against the law, and the person can report it against the company, right, sir?
See, what we are saying, that we had the act, we said Standing Orders Act of 1946, right? 1946 made the terms and conditions of employment compulsory. And in the terms and conditions of employment, the very first clause is how much salary they are going to get for a particular position. Therefore, when the positions are advertised, they cannot basically tell at that point of time that we will not let you know what is the salary that is attached to this particular position. So they have got to declare the basic pay that it involves, the particular position involves. They may say that if somebody has got higher qualification, it is negotiable. That is, minimum is guaranteed. Over and above that, it can be negotiated while you are interviewing. So what happens, that there are advance increments which is being given to individuals. Now those advance increments can be the normal increments of 3% or 2.5% in the 6th pay commission, or 3% in the 7th pay commission which is there. So the person will get equivalent of that percentage every year, whatever is the basic, 3% extra if one increment is given, or 15% extra if 5 increments is given. But they have a limit that not more than 5 increments can be given to any individual if their qualification is higher, so that a differentiation could be made between the base of somebody who fulfills the base qualification and somebody who is having higher qualification and opted for a particular job. So that differentiation is there so that a person remains satisfied. Okay. Now what happens, that if you have agreed to give them an advance increment while the interview was held, and later on you say, no, you have to remain on the same salary. It also happens that if you were working somewhere in a public sector organization, in the government sector, on a higher salary on a particular position. Say, for example, look at the job of a teacher. If somebody was working as an associate professor somewhere and his salary was at a higher level, but he applies elsewhere and is appointed, but the advertisement mentioned the base salary. So his salary protection will be done. Whatever salary he was getting earlier, his salary will be protected. And therefore, on the forms that we know, a clause is there, is the minimum salary acceptable to you? If answer is no, state what is the salary you are expecting and the reasons thereof, right? Now, if you have mentioned that and you are appointed and you are said that you will be getting the basic salary, it's a dispute. That will be referred to the National Tribunal. Okay?
Sure, sir.
Any other question, please? All right, I'll start the new topic tomorrow then. Thank you.
Thank you so much, sir.
Thank you, sir.
So
Thank you,
Sir,
sir.
in previous session, you discussed about the assignments. So when can we expect them?
I'll give you the topics maybe tomorrow or day after. I'll
Sure,
send
sir.
you that in the
Okay, sir.
WhatsApp message. All right. Thank you.
Thank you so much, sir. Take care.
Thank you, sir.